That reminds me of this story. So there was this townhome owner who thought he owned the lake in his complex. Well, the truth is, he did not. But what he did have was a waterfront view, which was actually spelled out in his deed. And so he was pretty peeved when the condo association put up a sign that restricted him and other owners from going down to the lakefront. Now he sued the HOA and eventually won the case. In fact, it went all the way up to the Supreme Court. But before we get into that, here's why. About 20 years ago, Edward Pomerantz bought a townhome in the Sleepy Hollow Lake Club in Miami, Florida. It was a beautiful waterfront property with a swimming pool and, of course, direct access to a lake. Now, Edward wasn't the only one with a waterfront view. There were 5 other townhomes in the complex that also shared that perk. However, those other homeowners purchased their properties without that exact language. In their deeds, Edward's deed, though, read, "The grantor grants to grantee, subject to the provisions of this declaration, a non-exclusive easement to use the lakeshore and docks located adjacent to the property. Nothing herein contained shall be construed to grant any ownership interest in said lake." Okay, so the deed says he has access to the lakeshore and docks. But what does that mean exactly? Is he allowed to wade in the water? Is he allowed to dock his boat there? Or is it purely aesthetic? Well, that question remained unanswered until another homeowner proposed a plan to build a seawall to protect the shoreline from erosion. This proposal went before the condo association for approval, and the association rejected it because they claimed ownership of the lake and the shore under the idea of adverse possession. That term means that if someone openly and continuously possesses something that belongs to someone else for a long enough period of time, that person may acquire title to that property. Now, the tricky part is that this concept of adverse possession varies greatly from state to state. Some states say 7 years is enough time. Other states say 20 years is long enough. And then there are other states where it's as long as 100 years. Now, the facts surrounding these cases are also important. If your neighbor comes over and asks you to mow his lawn while he goes on vacation for a month, and you do that for him, well, I doubt that that's adverse possession. However, if you walk into his house, start taking care of his children and tell them that he doesn't need to come back because you're now in charge, well, yeah, that might be adverse possession. But this case was different because the association had never paid taxes on the lake. They hadn't maintained it, cleaned it, or repaired anything. In fact, the association explicitly gave permission to the individual homeowners to do those things. So obviously, he didn't think that he owned it. And this whole time, Edward enjoyed his lakefront access, even though he knew the HOA was claiming to own it. That was until the association started sending him letters demanding money to maintain the lake, and that's when he finally decided to fight back. The lower courts. The trial court ruled in favor of the HOA, arguing that the association had exclusive rights to the lake under the theory of adverse possession. On appeal, the 3rd District Court of Appeals reversed that decision, pointing out that the association had not paid taxes on the lake and that the property description in the master deed did not include the lake. That deed identified only the individual parcels and common elements that were subject to the association's control. Although the association argued that the master deed included the lake within the phrase "all areas," the appellate court disagreed. However, Edward's victory was short-lived. The Florida Supreme Court took up the case and issued a ruling that once again favored the association. The court stated, "We recognize that in some circumstances, such as where the disputed property is physically separated from the dominant estate by the property of others, the grant of a limited easement will be exclusive to the expressly granted tract rather than extending to adjacent natural features. However, this principle is not applicable in the present case. The lake is landlocked and surrounded by residential units. The restrictive covenants manifest an intention that the lake be treated as a common element and devoted to the common use of the residents. Moreover, the inclusion of the lake in the description of common areas contained in the declaration demonstrates an intent that the lake be considered a common element. So, the court ruled that the HOA had exclusive rights to the lake because it was evident from the record that the intention of the parties was that the lake be treated as a common element. However, this case was different. The court acknowledged that the language in Edward's deed was ambiguous as to whether he had the right to go down to the lakefront or not. So instead of leaving the decision up to the condo association, they kicked it back down to the lower courts to determine Edward's specific riparian rights. After another trial, the judge ruled that Edward did not have a prescriptive easement to the lakeshore because the record did not show that he had continuously used the lakeshore since he bought the property 20 years ago. In fact, he had only been doing it for 2 years at the time of the lawsuit. But that still left the question of whether he had a view easement. In simpler terms, does he have the right to enjoy the view of the water, or does the association have the right to block it? After weighing the evidence, the court found that Edward did have a view easement. In fact, the court determined that all the unit owners had implied view easements to the lake. The case goes to the U.S. Supreme Court. Eventually, the case made its way up to the U.S. Supreme Court, and on March 2005, the court handed down their decision. The ruling was that the court agreed with the Florida Supreme Court that the lake was indeed a common area, and therefore the HOA had a right to restrict access to it. But the opinion also made it clear that the HOA could not outright terminate Edward's view easement. In fact, the court stated that the HOA could not interfere with the reasonable use of these easements. That meant that the association couldn't shut off Edward's view to the lakefront by building anything in the way. But it also meant that he couldn't just stroll down to the lakefront whenever he wanted either. Instead, the court stated that the best approach would be to give Edward and the other homeowners the right to access the lakefront so long as it was reasonable. In simpler terms, the court suggested that the condo association should allow the homeowners to cross over the common area to get to the lakeshore. So essentially, the Supreme Court ruled that all the homeowners had the right to the view and the right to cross through the common area to get there so long as it was reasonable and didn't disrupt the other residents. So remember, just because your neighbor lets you borrow his lawnmower doesn't mean you can take over his life. And just because you have a view of the lake from your backyard, it doesn't mean you have a right to walk across someone else's property to get there. And thanks for watching. If you enjoyed this video, please subscribe to our channel. Until next time.